it's not just finances, but investments as well. So with that said, there is room for us to learn more and educate, and we're going to do it differently to the way men, because we're not men. So it's been the gray hair, gray suit model for a long time, called the penguin model. But we're going to change it and we are going to call it the peacock model for ourselves. What that means is whatever we fancy and however we want to spread our feathers, that's what we are going to do. So no more being held back from being on the golf course or invited to a hunting trip. We've got our own thing going. Okay? So a lot of this is about education. It's about encouraging one another. I know some of you over the months that we've been doing this have really got to know one another, form relationships, and I know over time you're just going to be there for one another in your different places in life. And also we just want to engage and want to work together, interact. I know a few weeks back, some of you really participated in a big way. Roseanne, you contributed and shared your experience, and other women gave their stories, and so it's going to be open for us all to do this together at different points in time, and in between will be the education. Tonight we're going to continue on from last month. We were talking about the what if, but before I go into all of that, I just want to say special welcome to those of you who are guests tonight. Thank you for coming out here to our Wild Women's Group. We're glad to have you. We hope you learned something interesting. But I'm going to be just giving a little piece at the end, but our real speaker tonight is going to be Kaplan, who I'm going to introduce in a few minutes. She is an attorney, and she's now going to bring in the some more depth from what we left off last time. But when Susan comes in, I'm going to give an official introduction, so I'm going to repeat some of this in a few minutes for the sake of the recording. So, are you recording now?
Yep, it's already recording, but I'm going to cut this part out. So if you want to go ahead and announce about the recording.
Yes. Okay, sure.
Yeah.
So what I just wanted to say ladies tonight though is we are going to record the event. Again, it's really fabulous information. And if you could, if you've got questions, if you don't want to be heard on the recording or make a part of the recording, would you just write it down or refer it till the end? Mary has agreed to do question and answer with us at the end. So we'll make it available to speak up, interact, and say what we want to say. Is that fair enough? Mm-hmm. All right. So like what we're trying to do here at the Wild Women Group is it's a monthly educational workshop. We literally do these once every Thursday, first Thursday of every month at 6 p.m. and that's what we're about tonight. At some point, we're going to be involving services, community outreach, serving the community. As a company as a whole, we do give back to our community, and I know some of you have been with us on some of our serve days and our events today. We want to do that as well. We want to give back. Another piece that we have for you is our travel concierge experience, which we've been speaking to you about over the months. A lot of our clients are retired now. One of the things they really want to do is travel. But with that travel, we always want to create a fantastic experience. And so we partnered with a travel concierge, started a company there, where we want to make sure you get really good travel experiences. So that's what that's about. And then of course we're going to throw in other social and engaging opportunities. So again, I just recap, we're about engaging and encouraging and educating. So that's what we want to do for each other, okay? All right, save the dates, ladies. Our next event is coming up on May the 5th. At that event, we're going to have Keith Coker talk about fraud and cybersecurity. Pretty important these days. So I think that would be a good one to come out for. And on the following event, June the 2nd, that Thursday, we have our very own Jeremy and Hilton from the office. Some of you know them, right? Well, they're just going to run through your brokerage statement. Literally, do you know everything on your brokerage statement, what it represents, how to even read a brokerage statement? So that night is going to be, we're just going to walk through a Fidelity brokerage statement and point out what we need to know on that, okay? So again, that's beyond some of you. For some of you, it's really important to get that understanding. So we're going to be at all different levels here. But tonight, our topic, as I said, is estate planning. We are following on from last month where we said, what if the unexpected happens? How do we begin to prepare for the unexpected. And tonight it's just going to be a bit more informative and educational, more practical last time. And I have with us tonight a wonderful woman who has given up her time. Her name is Mary Kaplan. She is going to speak to us. She's an estate attorney, very local to us. And she's agreed to give her time to talk to you about the legal documents, what they are, why you need them, and most importantly, she's going to address some of the common mistakes that she sees made during her practice of working with people. So I can just read off from her bio. Mary graduated magna cum laude with a Bachelor of Arts in History from Ohio State University. Mary obtained a Doctor of Law degree from Emory University and is licensed to practice law in both Georgia and Florida. Mary previously practiced law with a boutique estate planning firm in Atlanta, Georgia, and was a certified financial planner with Cody, or I met her, we had this little conversation, and this is what makes it really special to have Mary with us tonight. She actually has a background in financial planning, and so she understands the two worlds, our financial world, the legal world, and how they overlap, because we do overlap in a very big way. So she got started in her career doing something very similar to us. She advised high net worth clients using cutting-edge estate tax, income tax, and child planning strategies. Whatever you ever heard of that before. Mary has had her own law practice in Florida for the past 12 years. You're very close to West, aren't you? Where exactly are you? Metro West, yes. Yes. She currently practices estate planning, probate, and guardianship, as well as elder law. She's a member of both the Florida and Georgia bars. She's been admitted to practice in the U.S. District Court, Middle District of Florida, and in addition, Mary is a member of the Orange County Bar Association and Florida Bar Real Estate and Trust sections. Originally from Northampton, Ohio, Mary currently lives in Orlando with her husband Steve and her 2 boys. They're boys, right? Children. One of each. One of each, sorry. In her free time, Mary loves cooking, reading, and working out. So she just doesn't look old enough to have done all of that. There we go. I'm very grateful to see you. So I'm going to hand it over to Mary right now, okay? And I'll come back up to so thank you so much.
Thank you so much. I'm happy to be here with you all tonight, and thank you for allowing me to speak about this topic. I've been practicing estate planning for a total of 22 years. 12 of that is in Florida, the rest is in Georgia. I'm still licensed in Georgia, as was mentioned. And I also do probate, so I see kind of both ends, the planning, the beginning stage, and then probate when people pass away. We do trusts as well, and then guardianship and elder law. So any kind of like Medicaid planning is typically what people mean when they say elder law. Sometimes they mean guardianship. We do all of that. So without further ado, let's go on. Okay, so let's just start from the basics. I'm sure some of you know all of this already, but I just want to go through for those who might not know as much as everybody else. I just want to start from the beginning. So the basics are, I'm going to be talking about wills, trusts, powers of attorney, and then common mistakes that we're seeing here. So we're going to cover why you need a will whatsoever. We're going to start with that. Then what is probate, because some people don't have a real good idea what that is. Why do I need or might I need a revocable trust? How to deal with out-of-state property, and then some common mistakes that we often see in planning. Okay. So reasons that you need a will, and these are just a few. These are the ones that jump out the most. If you have minor children, you need a will so that you can name guardians in case something happens to you if you're a single parent, and both you and your spouse if you're married. In order to avoid a court battle, unfortunately, I have seen this before. People battling with each other, different sides of the family, to try to get guardianship of the minor child. And that can be addressed in the will. There's not actually another document that you can do that, but very few people know about. It's not always commonly done. It's called pre-need guardian for minor child. I do those sometimes as part of my package for people that have minor children. And that can address also the situation where you become incapacitated. You're not deceased, so you're still alive, so your will doesn't have an effect because because you're still alive, but somebody does need to step in and take guardianship, you can cover all your bases if you have that document as well. Older parents, a lot of times, especially with my clients that don't have children, a lot of times they tell me that they want their parents to be the beneficiaries under the will or trust. A lot of times it's not the best idea, and there's numerous reasons for that. First of all, they might not need your money, and hopefully they don't. Hopefully they're doing really well and have everything in a row. And being older, they don't. They might rather that you give it to someone younger in the family or a charity or something like that. And then in addition to that, there's the whole Medicaid issue, which is a whole nother topic. But a lot of times people who are older are trying to plan for the potential that they might have to go into a facility, or that they might require caregivers to come in and take care of them in their own home. And these days, a lot of people don't have long-term care insurance. It's very difficult to get. It's very expensive, and it's very difficult if you don't really try to get it until you're older, because by then you're not going to underwrite you. So a lot of people do not have long-term care insurance. So how are they going to pay for this? And I'm not going to spend too much time on this, but it's very, very expensive. Assisted living is average $5,000 a month in the Central Florida area, and skilled nursing is average $9,000 a month in this area. So you think about that and how quick your money can go. A lot of people are trying to get qualified for Medicaid or VA or both in order to pay for that. So the last thing that they need is you giving them more money. They don't need that. And I should say, if you don't have a will and you're not married and don't have children, your parents would be your heirs at law. So they would end up inheriting if you do nothing. So it's another reason to have a will. And I should also mention, and we're going to talk about intestacy law, but if you want to do something different than intestacy law, which is what happens if you die without a will, then you're going to need to draft a will. Okay. So wills can be and should be used often in conjunction with revocable trusts. So if you have a trust, you also need a will. Some people think they don't need a will if you have a trust. And I can understand that, because a trust is like a will substitute. It functions like a will, okay? Because it says who's going to get your property and assets when you pass away. That's what people think usually when they think of wills. So it's like a will substitute. However, you would need a will as well as a trust, because just in case, usually at least one or two assets, even the people who plan the best that are super detail oriented, there's usually one or two things that they might forget about and they don't actually transfer into the trust. We're going to get into that as an issue later in the presentation. But you need a will to kind of clean up anything that falls outside of the trust. And so I mentioned this already. If you die without a will, that's called intestacy. And that means that the courts and the Florida legislature, when they draft the laws, they determine where your assets go, not you. So you kind of lose control of any of that. Okay. So this is Florida intestacy law. So if you pass away, and this slide is all about if you have a surviving spouse. So if you're married when you pass away, your spouse has survived you. And all your children are also the children of your spouse. Okay, so you've got children, but they're your children together, and your spouse has no other children outside of the relationship. Okay, 100% of your assets would pass to the spouse if you have no will. But if you or your spouse, this is where it's really interesting the way they drafted this law, you or your spouse have children from a prior relationship, then only 50% of your assets go to your spouse and 50% go to your descendants, which means children. And then if you had any deceased children, and they had children, they would go to their children, which are also your descendants. It descends down the family tree. Okay, so we can talk about why they did it this way, but it often does surprise people, because it's like, well, of course, my spouse is going to inherit everything. Well, not necessarily. It depends on your situation. So you just need to kind of be aware of that. Okay, so here's the intestacy law. If you have no surviving spouse, so you're not married at the time you pass away, and you have descendants, again, that means children and or grandchildren, then 100% of your assets pass to the descendants, but you have to also think it goes outright, because the legislature didn't draft any sort of trust holdback provisions for children when they drafted this law. So if you have minor children or if you have a deceased child with minor children, so minor grandchildren that would end up inheriting under this law, that means that those minor children are going to inherit this money outright, free of trust, which then means that someone will have to go to an attorney and set up what's called a guardianship of the property to oversee those assets that were descended and were bequeathed to under intestacy law to these minor children until they turn the age of 18. And then at that time, they get the money. So no matter how much money it is, $500,000, $1 million, whatever, they get it at age 18. So most of the time, that's not a very good result. Okay, and so if you have no surviving spouse and no descendants, so no spouse, no kids, grandkids, that's where I was talking about parents, then 100% of your assets would go to your parents. They would be considered your closest living heirs if either one of them was still alive. And then if not, then your siblings would be your closest heirs and deceased. This is kind of a little mistake. Siblings and deceased or children of a deceased sibling. So if you had two siblings and one had deceased, one sibling would get 50%, the other's kids would split that 50%. And if there's no siblings, then it's nephews and so on. So this is all good information to have, because if this isn't what you want, then you need to. Okay, so here's another big overview question. What is probate? So probate is a court case. It's a legal process where the court makes sure that your will is legally valid, that your debts are paid that are valid, and that your assets are then distributed at the end according to your will or for law if you have no will. So a lot of people get tripped up on the will is legally valid thing, and I have this issue happen recently where these people did a will, and we'll get into common mistakes. Maybe I should have because actually I don't have a slide for that, so I'm going to just intersperse common mistakes. So a very common mistake is people trying to either draft their will themselves using like some kind of software they bought at Office Depot or whatever for $50, or, and this is almost just as bad, going to an attorney who doesn't do estate planning. Because I can tell you, I mean, I learned about real estate and like I learned about some other topics, in law school like criminal law, but I don't remember that. I mean, I am not competent to defend somebody in a criminal trial today. I mean, that was 22 years ago. I don't remember. And so people who claim that they do it all are not telling you the truth. So I had a will, someone come in, their father had died, he had a will that was supposedly prepared by an attorney, but this attorney clearly didn't practice estate planning. It wasn't drafted very well, and then the problem ended up being, so we see how the court determines the most legally valid. We kind of just gave it to the court and like, because it's the original, we have to give them the original required by law. We knew there was a problem with it, and we're kind of just like hoping that we didn't notice. But they did. So one of the many problems is that the witnesses' names were not legible because they wrote it and we could read it. And then the witness address wasn't correct, and also they had written different names. So there's two different places we did write witness names. And one of the other places was a different witness name, so it didn't match the other one. So the judge was like, no, I'm not. Yeah. You have to basically, so when that happens, they attempted to do what's called a self-proving will, which is what most attorneys do. If you go to an attorney who knows what they're doing, they're going to do something called self-proving will, even if they don't probably software addresses for you anyway. There's a second signature page to a will that's called a self-proving affidavit, although it doesn't always have that title on there, but that's what it is. It's a second signature page that's notarized that the testator, which is the person signing the will, and the witnesses have to sign again, and then it gets notarized. And so that is how you self-prove the will. So that is how when you submit a will to the court, that's how you avoid the problem of having to track down witnesses from whenever this took place 10, 20, 30 years ago, whenever this will was signed. Okay. So that's great, except for they screwed it up. So then we had to go and prove the will. So they actually had done this recently enough where they did know one of the witnesses, the family knew one of these people. So we were able to track down the witness. But then this is where my memory fails me. There was some sort of a problem with that. I can't remember what that problem was. Whether they weren't willing to sign, I don't remember. But there's another way you can prove a will, which is called an oath. I forgot, but some sort of oath that the guy who was named as personal representative had to sign. And that was our client. He was the one named as personal representative. So he was like, fine, I'll go. They have to go to the courthouse and execute this oath. And so he did. And then he messed that up. So basically, I don't have a withdraw because he took a different. So I think what he did is he tried to fix the problem with the will by going back. He had some sort of a scanned copy, and then he tried, and it almost looked like he physically cut and paste, like the old-fashioned way, like took a piece of paper and then covered up something, and then typed or wrote the names. So he was clarifying what was his names. Well, you can't do that. That's a fraud on the court. Because that original will is the will. You don't have more than one will, you have one, the last will and testament. That's why it's called last will and testament. So that got all screwed up. And so now I'm in a position where I cannot continue to represent them. But that's an extreme case. But anyway, the will is, the court determines whether this will was legally valid and whether it was done correctly with the correct execution requirements. So if somebody screwed up the execution, it's going to create a huge problem, and you're probably going to end up wishing you had just done a test to see if that held up, because you're going to have to go through this whole process of proving. Your debts are paid, so that's creditors. So we'll talk, we can mention creditors here, I guess. So one of the problems with probate, one of the issues that comes up all the time are creditors, because when you open a probate case, you have to notify any known creditors, so people that have been sending bills to the decedent, and you have to publish the notice in the newspaper for 2 weeks, and then wait 9 days for creditors to come forward. So there's a built-in delay there with waiting for those creditor claims, and then you have to deal with them as they come in. So this ends up being a big job for the personal representative, because they're the ones that are going to have to deal with all of that. Now, sometimes they can ask us to do it, and we will, but first of all, not all the creditors are willing to, some of them want to talk directly to the personal representative. And then second of all, they have to pay us, and we charge out usually for probates, because we never know how much time it's going to end up taking us. I do flat fees for a lot of like planning work, like wills and trusts, but I charge hourly when I'm doing probate or any sort of court case usually. And your asset, and then they make sure your assets are finally distributed. So there's a waiting period in here where everybody's waiting for their money. So you could do an advanced distribution, but everybody has to usually agree on that, otherwise they're not going to do it. So if people are not getting along with each other in the family, which is another common thing that happens after, especially after the mom dies, very interesting psychologically. It doesn't always happen when the father dies, but when the mother dies, it seems like that's when all hell breaks loose. So it is bureaucratic. Like I said, there's built-in delays. There's all different documents that you are required to file support. It's costly because you're paying attorney fees. And on top of that, not only paying attorney fees, but I should mention that under the Florida statutes, your attorney is entitled to take roughly 3% of the total value of the probate estate as his or her fee. And the personal representative is also entitled to take roughly 3%, depending on the total value of the estate. It's right around there, of the total value of the estate as his or her fee. Or they can charge hourly, and attorneys can also charge hourly. And like I said, I usually charge hourly, but a lot of attorneys will do that fee. And then a lot of times they end up getting a lot more money than they, compared to the amount of work they actually did. But anyway, and so these are common problems that happen in probate. So yeah, so I kind of talked through all this, right? That's about it.
Is that 3% of what goes through probate or the
Yes.
estate?
It is 3% of what goes through probate. So I'll tell you this because I don't think I have a slide on it. Homestead, like your primary residence in Florida, is not technically an asset in probate. So Florida is a very unique state that way. I don't know if there's any other states that have that rule. Because most states just treat a home like any other piece of real estate, but not here. Here, homestead comes with all sorts of benefits usually for people. It's meant to be a positive thing. They could get their homestead exemption from property taxes, and then you get your homestead exemption and bankruptcy, and they're very generous with the exemptions there for it. And then it is an exempt asset from creditors in probate. And so and because of the way it's handled in the Constitution, it's not truly considered a true probate asset. It is supposed to, under the state constitution, descend to your spouse or your children, and there's all sorts of built-in protections for that. So we actually, because it's not a true probate asset, we don't count the value of the homestead when you're calculating your fee. So that's kind of good, I guess.
So if your home and half your assets are in your trust.
Yeah, we're gonna talk about trust. We're gonna talk about trust. Yeah, so trusts are the best way to avoid probate. It takes time to go through probate. Usually for a formal probate, which is the full-fledged case, if you have more than $75,000 in assets at death, exclusive of homestead and all that. It takes usually 9 months to 2 years. However, I have seen them last longer. I had one that I got hired onto that had been going on for 10 years. Why? Because of the attorney, because of my opposing counsel. And because, again, he was able to take advantage and manipulate them back then. The family just hated each other. Like, they were just at each other's throats, and they would not work together, and they couldn't even be in the same room with each other. You know, that was a nightmare case, and I would never take a case like that again. But I learned a lot. I learned a lot. So, and during this time, the assets could be frozen. Like I said, sometimes they do advances, but a lot of these things require everybody to agree. And if you can't get agreement, then most of the time, the personal representative is not going to stick their neck out and do things like that, because they can be sued. If they do something, they have a fiduciary duty to administer its estate for the benefit of the beneficiaries and creditors, usually. So they have to make sure everybody's treated fairly and paid and all this. So, I would tell them not to do it if not everybody's afraid to do it. Loss of privacy. This is another one that sometimes surprises people, is that your will becomes a public document after you pass away. Like I said, you have to deposit the original with the court especially within 5 days of the person's death. Doesn't usually happen, but that's the law. That's what it says. But anyway, when you do deposit it, they scan it into the docket, and then they don't publish it on the online docket. But if people are curious and nosy, they can go down to the courthouse and they can just request to look it up, and they're perfectly entitled to do that and get a copy of it and see if you gave the money to them. All their business, they can see that. Which is not the case with the trust. We'll talk about that. Loss of control and intervention of the court. So the probate judge has supervision over how the will is interpreted, like I kind of mentioned. How much it will cost, because how long it will take determines usually how much it will cost and what information is made public. And so they can make you come in for hearings if they feel like it. There are some judges that really like to do hearings for everything, which not only is a pain, but it's also more money. We have to bill for our time and hearing and all that. If they don't like certain things, then you have to do them over. I mean, you could try to fight it, but if you're going to spend more money trying to fight it, then you would have probably just did it the way they told you to do it. So they have a lot of control because it's a court case and they're the judge. And then this got on the slide, but this is a point that I wanted to mention. The wills cannot plan for disability, so this is sort of a reason to do a trust. So I'll just hold on that until.
When your will goes to court, is that a private courtroom, or is that a courtroom that's open to people like you're saying?
Good question. So you mean like if they ask for a hearing or something? Yeah. So these days, in Orange County and in most counties, the hearings are actually virtual. Like Orange County does them in Microsoft Teams, which is nice. I think it's nice because I invite us to try the courthouse and everything. So technically, I think they're supposed to restrict who can come in, and usually people don't like public. You don't get the link. You have to have the link, and then the judge admits you, like admits somebody into the same room. But we had a case where there were just 2 people attending in the virtual hearing, And that was actually a guardianship piece, but guardianship pieces have even more privacy restrictions on them than probate typically. And they let these people in, and we still don't know why. It's just up to the judge whether or not they're going to let people in the hearing or not. Why do you need a trust? Okay, so we talked about all the horrors of probate. So the most popular and easiest way and best way really to avoid probate is to do what's called a revocable trust, also called living trust, also called revocable living trust or inter vivos trust. It's all the same thing. It's a trust that you draft and you set up while you're alive, you fund it while you're alive, which means you move the ownership and the title to your assets into that trust while you're alive. You don't wait until death because that sort of defeats the whole purpose of the trust. How it helps you avoid probate is that to the extent that your assets are owned by a trust and not by you, when you pass away, then there's nothing to go through probate because there's nothing in your name. There's no assets in your name that have to get moved out of your name. Everything is owned by the trust. So during your life, you're the trustee usually. Sometimes with elderly people, they don't want to be the trustee. When they set it up, they'll just have usually their adult child or somebody, and that's perfectly fine. But typically people want to be their own trustee at first. And you're also the beneficiary, meaning you can use the money for your own benefit, however you see fit. So there's no real restrictions on anything you can do with your money once everything's in the trust. It's really exactly the same as far as how it feels, what powers you have, what authority you have. There's no restrictions on any of that. And the way that we do them, I know some people do them differently, but I think probably 90% of attorneys, we don't get a separate tax ID for the trust. We use your social, and that way you can avoid getting any extra tax credits while you're alive. So everything flows through and gets reported the same way as before. So it makes it nice and easy for you. And then after you pass away, that's when your successor trustee will follow and get a tax ID number, and then it's taxed as a separate entity. But during your life, it's sort of like a see-through entity. Everything is taxed to you, and you're the one in control, and you use the money for yourself. Now, some people think it can help you protect assets from your creditors, which would be great, but unfortunately, it does not do that. You know, it can't do everything. And that is because it's so flexible and because you have control and authority over it, the law does not allow you to hide behind, use this as a shelter if you're the trustee and the beneficiary. You don't get that benefit because it is sort of like a secret entity. However, it'll protect the assets of your children's creditors. If you have children that possibly, are subject to lawsuits or even divorce, that person, an ex-spouse is a creditor, just like any creditor. So if you have concerns with that, you can put your assets in the trust and keep them in the trust for your children after you pass away instead of giving them directly to the children. And of course, that's always a good idea with younger. You have to do it with minor children, and it's always a good idea with people even, I would say up until 25, kind of the minimum in my experience. It's just a good idea. Okay, this is another big one. Avoid a court-managed guardianship over your assets if you become mentally incapacitated. So this is something not a lot of people think about when they think of trusts because they just think of avoiding probate. But especially these days, people are living longer and longer. A lot of people towards the end of their life are, they have dementia, Alzheimer's, Parkinson's, whatever it may be that affects their brain. And so they're losing their capacity. And at some point they've lost it. And obviously there's no right line to where that is. But, if they lose their capacity and they don't have a trust, and they have everything just sitting in their name and their accounts, then if they start, not necessarily, this is not a necessary thing that's always going to happen, but if they start to act irrationally and do things like I had a guy that was just like giving money away to people he had met for 5 minutes, or giving away, a lot of them give away their social security number, because the scammer, telephone scammer will call them, they'll give them whatever information they ask for. If they start doing things that are detrimental to themselves or others, we've had somebody set fires and things like this. The only way to really stop them from those behaviors is to get guardianship over them. It's sort of like an establishment of a relationship, like a parent-child relationship. Where now, once you get appointed as guardian of somebody, now you can make the decisions for them financially and personally. So you can make sure they get medical care that makes sense and take them to the doctor, and you have the authority to decide on courses of treatment with that whole guardian of person aspect of it. And then as far as guardian of property, whoever is the guardian has the authority to do all of your financial transactions for you, to invest your money, to buy and sell. Some of this requires court permission, and because it's a court case, it gets set up with the judge supervising it.
How does a guardian differ from a POA?
It's different in that it's more powerful. So a guardian is more powerful than an agent of power. So that's the thing. So if you would come into me and you decide you just wanted to do a will and no trust, which happens, some people don't need to do a trust. If you do a will, I always will, and most attorneys will also draft a power of attorney, sort of like a document package. So there'll be a power of attorney and a healthcare surrogate, a few other things. And typically, for people who age and may develop Alzheimer's and dementia, as long as they have a power of attorney in place and a healthcare surrogate, the designation of healthcare surrogate, then they're usually okay, and they don't usually need a guardianship because they've got somebody over here making medical decisions for them, and they've got somebody over here making financial decisions. And as long as, you know, nothing untoward is happening with those people, which sometimes does, then they're fine. They don't need a guardianship. But like I said, if they start doing things that are harmful to themselves and others, and unfortunately that does happen, even if they have the power of attorney and healthcare surrogate, sometimes we have to still open a guardianship over them. And then a guardian gets appointed to make all their life decisions for them, and the court will override, supersede the power of attorney and the healthcare surrogate. So where I was going with that is that if you had, let's say that situation happens to you, let's say it does. If you had previously set up a trust and funded that trust by moving your financial accounts into the trust, into the name of the trust, then even if you need a guardian later, you still don't need a guardian of the property because you've got a trustee, a successor trustee in your document that you picked and you named when you drafted the trust. And that is the person who will now have the authority, power, and control to invest and manage your assets for you. You may still need a guardian of the person to make sure you're taking care of yourself and get you to the doctor and make medical decisions for you, but you will not need a guardian of the property, which is really great because guardianship is a court case, and guardian of the property every year have to do an annual accounting, which can be very, very time consuming and therefore very expensive. You have to have an attorney, you have to be represented by counsel if you're a guardian, period. There are some exceptions in guardian advocate, which is guardians and people with disabilities that they were born with, but that's the only exception. So all other guardians have to be represented by counsel. So of course there's attorney fees and all of this. And then if you have an attorney doing the accounting, it's probably going to be expensive. So not only does a trust help you avoid probate after you pass away, it also helps you avoid guardianship of the property. That's what it's called, guardianship of the property. You maintain control of your assets, so you don't give up any control because you'll be your own trustee probably. And then you will name at least one person as your successor trustee in case you either die or become incapacitated or just step aside. Like, you know, people are like, look, I'm 90 years old, I don't want to do this anymore, I'm fine, I'm going to step aside and decline to serve. And that's when their successor can step in. And so it allows a seamless transition of the management of your assets. So if you're doing it right, you're going to fund the trust, and you're going to go and work with this group of people that I'm sure they will help you, retitle those assets. And you're probably seeing that all the time. Right. So if you work with a financial advisor that's worth their salt, they're going to know how to help you do this as far as retitling those accounts into the name of the trust with you as trustee instead of just you. And so if you do it right, you got that done, and then you got a successor trustee name, this will be a seamless, smooth transition. It will not be, the chaotic mess that can happen when, dad has all this property and all this money has been all of a sudden he's Alzheimer's, he's got no documents, And everybody's upset anyway, because he's doing all these irrational things, and everybody's trying to make sure he's okay, and then trying to get a hold of that situation and figure out what's going on with that. It can be very, very, very stressful for the family. So this is a lot better if you can do it this way. But they're only effective if you fund them, which is what I was talking about before. So how do you fund a revolving trust? Okay. So with real estate, you're going to retitle it just by using a warranty or a quitclaim deed. I prefer warranty deeds because they preserve all the warranties and title and all that. It'll do the same thing though. So you're going to just, when you go to an attorney, they will talk to you about this, hopefully if they're good. They'll talk to you about, okay, here's the trust, and then we need to do all these deeds for all these properties to actually transfer those properties into the name of the trust. And then you actually sign and execute it and then record it with the county, each county where each property is. Bank and investment accounts, like I said, they get retitled, just the title on the account. If you have a financial advisor, then you probably can just email them and she'll talk more about what they need specifically. And you probably can just email them a copy of the trust and say, good to go, and it's help me with this. If you don't have a financial advisor, you'll just do a basic cover letter to the bank or the financial institution and say, to your bank, I have executed this trust, effective this date, here's a copy of either the trust or there's a certificate of trust that I always give clients. It's like a short form summary. You can give them that and say, please retitle this account into the name of this trust. Don't ever walk into a bank branch. My clients do this all the time. I tell them not to, but they still do it anyway. And it's just usually a very frustrating experience to, I'm just gonna go visit my local bank or go to the bank branch and bring my trust and they're gonna help me. Well, the people at the branch are not usually trained on how to do these things. So I have them tell clients all the time, we don't do trust. You can't do trust here. No, or you have to close this account out altogether from this new account. Now, there are some banks, there are few that do have that policy for some inexplicable reason where they will make you close the account and open a new one. But most of them do not have that policy. It's just a matter of talking to the right person. So I always tell my clients, just take a letter. I don't even give them a blank form letter if they want it, and mail it to the address on your statement where you see the little fine print where you can mail correspondence. That's what we always tell the clients to do. Now it's an online bank, you should have a way to contact them online, things like that, and you can still use the letter and scan or email that to that address.
How long does that take?
It can take a little bit of time depending on the accounts you have. Now again, if you work with a financial advisor, they're probably going to be able to help you faster that way.
Does it take a week? Or can you do that in 24 hours,
Well, see, you're dealing with banks here.
Yeah, I know.
So a lot of it's on them. I draft the documents, I give instructions, and then you have to go to the banks, which are slow, a lot more slow. I always tell people, I get it, like people want to spread out their assets in different banks, but try to consolidate as much as you can because it is really big administrative burden to try to, help be a successor trustee or a personal representative for somebody that had like 25 accounts in all these different banks. And it's not really necessary to do that. So anyway, it can take a little bit of time. Yes, it can. It's a little bit of homework for the client afterwards. And of course, we can do the service for them, but most clients want to do it themselves because we charge for our time and it can take time. But anyway, it's worth it in the end. You can take your time, do it in pieces, or utilize your financial advisor to help you out, and that'll get it done faster. Once it's done, it's done. It's in your trust, and your family has peace of mind because they don't have to scramble and do like a search and everything to try to figure out who had it out there after you pass away or if you're ill and everybody's scrambling to try to help you pay your bills, or that you qualify for Medicaid, whatever it may be. If they don't know where to bank and you keep things secret and you have 25 different banks, it's really, really hard on the family. It's much better to do it this way with the trust. And then oftentimes we'll do a schedule of assets to the trust where we list out all the bank accounts that we either have transferred or intend to transfer. And that gives like a really nice starting guide for the successor trustee to know where all your financial accounts are located.
If you have a bank account in two people's names, let's say two sisters, and one passes, does that go to probate or does that all go to the second name on the account?
It'll go to the second name. Yeah, and we'll talk about that a little bit too. Okay, so deferred, okay, so when it comes to deferred income, like IRAs, 401k plans, 403b, any kind of retirement plan, you don't actually retitle those, you just update the beneficiary designation to make it payable to the trust. Oftentimes, if the client's married, they'll want to leave their spouse as the primary beneficiary, and then I just tell them to add the trust as a secondary or contingent beneficiary. And that'll be a nice way to direct those proceeds. A lot of times that's where people's most of their savings are in these IRAs and 401ks. So we need to make sure that's a very, very important piece of the planning is to go back and check your beneficiary designations and make sure that they are reflecting your current plan. So if you set up this nice trust, you need to make sure that you've got it named as a beneficiary on your retirement plans.
Excuse me, so you name your trust as your contingency beneficiary, not your children?
Depends on how old your children are or adults, what you want to do, but if you have younger children, then I would say yes. Okay, yeah. It depends, you have to talk specifics. And same thing with life insurance. That's also where that money goes is dictated by the beneficiary designation form. So you always want to make sure that you double check all of that. One of the common mistakes, or that is a common mistake, is basically just not going back and checking the beneficiary designation forms and how you want people on there or no one, which is could be worse depending on who that thing. I had a guy, I felt so bad about this because he was a super smart guy and did all this planning himself. He was a CPA, he knew what he was doing, but when he went to fill out the beneficiary designation forms for his IRAs, his plan that he had developed on his own, because I didn't have him as a client where I met him, I think, once or twice, but I didn't do all of his planning. Anyway, after he passed away, come to find out when he did the beneficiary designation forms, he was off by one account number when he wrote the account number on the form. So his one IRA is just sitting there with no beneficiaries at all. So what that means 99% of the time is that it's going to go into probate. So it's going to become an asset of your probate estate. It's going to be subject to creditors, and it's going to be subject to attorney fees and personal representative fees and all of that. And in his particular case, he was thinking, because he was in a second marriage situation, he had children from the first marriage, and then he has wife, so he wanted to leave one IRA to his wife and the other one 50-50 to the two daughters, and that completely got messed up. And so then there was already a little bit of animosity between the daughters and the new wife, and that just blew it up into a horrible conflict. So that was a
Annuities have beneficiaries, right?
But you get the choice if you want to appoint somebody or not, they don't have to.
Okay.
So you can do, and that's another thing that people commonly do, like their own probate. So I can actually check.
Why can't a bank account have a beneficiary? Or savings?
So it can. So I'm going to talk about that. Okay. So another way, and this is popular, like to avoid going to attorneys, to try to avoid probate on their own, is to either name joint owners on everything, or do a transfer on death beneficiary or a pay on death beneficiary for their bank accounts and their financial accounts where you don't have an official beneficiary designation for the IRA. So the problem with that, there can be many joint. I really hate joint ownership if it's not spouses, because I was kind of trained on this back in the days when estate tax was the problem for a lot of people, because the exemption was $675,000 when I started practicing, which means if you have more than that, then you're subject to estate tax, which is really high tax. And it includes the value of like death benefits and life insurance policies. So people who don't think of themselves as wealthy are suddenly subject to estate tax. They didn't have access to this money, but it counts into their taxable estate. So anyway, when I first started practicing, we had this old lady who who had her nephew helping her out with her finances. So she was probably 90 and he was probably 65. So she just named him as the joint owner on her account, thinking that would be easier, and people always think that. And then he actually died before she did. And unexpected, I can't remember, heart attack or whatever, but she lived to be like 95. And then he had an estate tax problem because that joint account got counted, always gets counted as part of your tax of the estate. So it wasn't even his money, and they had to go through all of this mess. So that's one reason, although now the exemption is really high, so most people don't have to worry about it, but that can change, of course, and does often change. I was gonna say, the other reason for joint ownership is because a lot of people do it thinking, like they have multiple kids, and they'll say, well, this one child, there's always one child that's usually the primary caretaker for the parents as they age. So usually that's the child who will get named, if they're going to do it, that's the one you're going to name as the joint owner. And they'll say, yeah, this child just handles everything for me, so after I die, I'm just gonna name them joint owner, they'll inherit all these accounts, and then they'll take care of distributing everything out to everybody equally. I'm just saying that's what they think. And I definitely really believe that. And I'm gonna tell you, it doesn't usually happen. And you're thinking, then there's kind of, when you think about it from the perspective of the child, there's a reason for that. Because they did a service for a long time. A lot of times their siblings did not do their share of the work. So there might be some resentment there and some feeling of entitlement. Maybe they have a point, right? But there's other things you can do instead of doing it that way. You can give gifts, you can compensate them, which we do all the time in our Medicaid plan. We do personal services contracts, we actually compensate the child that's taking care of you on an hourly rate that's agreed upon, and as a contract, it's perfectly valid. So there's ways to do that instead of just naming them as the joint owner and then expecting that they're going to be Mother Teresa and do everything perfectly and distribute everything equally to everyone in the family without taking a little extra for themselves. Or just not sharing at all because they don't have to. They don't, and under laws, you can't sue them because they weren't doing the work. So unless you can prove that undue influence, which is very, very, very difficult to prove, they can just take the money and so that's one problem, the joint accounts. The other problem with joint accounts and with the transfer on death setup is that there's no flexibility built in. So let's say you decided to name you have one child and you come to me and say, I'm gonna name my one child as the transfer on death beneficiary for all his accounts, and he's beneficiary of all this other stuff, and therefore I don't need to do anything else on that. I don't need to do that. Well, the problem with that is, what if the worst happens and unexpected things happen in life all the time? So what if he dies simultaneously as you? What if he precedes you by a period of time when you're not able to update everything, or you forget to update everything? What if he gets sued? What if he develops an addiction to painkillers, which happens all the time, people that have surgery? There are all a number of things that can happen, and there's nothing you can do to fix it once that's done. Whereas in a trust, we have so much, like sometimes people complain because the document's too long. Okay, well, there's a reason the document's so long, because we build in all sorts of contingency planning and all sorts of allowances for what can happen with this, and we give a lot of discretion to the trustee to make decisions about whether or not I'm actually going to make a distribution to this person, because they have knowledge that that person has developed a drug addiction, or maybe the person was in a traumatic accident, has a PPI, and is now disabled. It'd be a bad idea to give this person all this money because Medicaid's probably just going to take it. All their creditors are just going to take it. So when you need to do this special needs trust, that's for another day. But doing the transfer on down or paying on that has no flexibility. It is what it is, and that money goes to that person regardless of what else happens. That's what's going to happen. And if they're dead or if we see, then there's going to be a huge probate, and there will if you decided you didn't need a will. So and then we talked about life insurance. Did I cover this? Yes.
Also,
this
this
is
is
so-
credit checks, right?
Sorry.
You put kids on your account, they're credit checks.
Yes, thank you. I'd like to mention that. That's another huge problem with joint accounts is that if you name your child as a joint owner on your account, if they get sued, you have now exposed all of your money to their creditors.
All your money or just that account that
Just
you're
that,
enjoying?
all your money that you have in that account.
Okay.
Okay. But that also includes divorce. I mean, think of how common that is. In a divorce situation, the ex-spouse can go after those assets that were yours. People don't think about that. And also people get into accidents, things happen. So even if you think you're, my child's really financially responsible, they'll never get sued. Well, things happen in life, and sometimes people do get sued and they don't think, it's not because maybe they even did anything wrong, they just get sued. So that's another big problem with joint accounts. So here's the overview of how a revocable trust works. So you transfer your assets to a revocable trust that you control. So technically, you no longer own anything as far as the state of Florida is concerned upon your death. You still pay taxes, but this is for probate purposes.
So if it's you and your spouse, you have one revocable trust with both your names, and you each have.
You can, and I do those all the time, actually. So let's go through this and then I'll talk about that. And so as the trustee, you keep total control, so you can still sell, buy, invest your assets the same as you did before. And since you no longer own anything, the courts have nothing to administer after you die, or if you become incapacitated and need a guardianship, there's nothing to be administered as far as property in that guardianship.
It's not now.
Yeah.
It's not now.
I don't know. Oh, yeah. So,
You mentioned joint, what about joint real estate?
so joint real estate is the same thing. It's equal ownership of an asset. So if your co-owner gets sued, has creditors coming after them, they can reach that. Now, if it's homestead, there's going to be some built-in protections on that from creditors. But that's only to the extent that it's claimed as homestead. So
But it's only that asset.
yeah, homestead is
No, I mean, if it's not homestead, it's only the asset of the real estate, right?
if that's the only joint real asset, yes. Okay, so no probate is necessary if you trust and fund the trust, and no guardianship needs to be set up for your property later in life. Oh, I wanted to mention out-of-state property. So a lot of people have out-of-state property, not necessarily foreign people, but a lot of people own property here that also own property in the first suburbs, right? So without proper planning, they may have to go through probate twice, once here and once in Michigan or Ohio, or wherever the other state is. And people don't think about that. And that also applies to timeshare. I get so many probates because people own timeshare here and they don't think about it. And they don't think about it as real estate, but it is. It's deeded timeshare. It is considered real estate and it's considered located here because it's deeded here. So even if you never use the timeshare in Florida, you're always like trading it out for other states or whatever, it's still a Florida probate asset. And so people are super angry usually when they find out they have to pay me to do a probate here if they want to take care of that, if they want to get that asset. And then of course, in the meantime, you're paying all those fees they charge for the maintenance. So it's very easy to deal with it. If you draft a trust, you also draft deeds to transfer all the real estate, including the out-of-state real estate, into the trust. And then you record the deeds in whatever the state is or the county is, where the real estate is located. And therefore you avoid probate in the other state and probate.
I don't know if you know the answer to this, but if you have property that you own for a long time and you clean deed it at $100, you then lose your basis points for it.
Yes, so, but not to a trust, do you need to a trust?
Yeah, if you go to a trust, you still maintain the original sale price or the original buy price and the improvements.
Yes, so if you transfer your property to a trust that you own and control, so a revocable trust like this, you do not have any negative capital gains tax consequence. So when you go to sell, you still get the same basis that you have.
From when you purchased it or approved it or.
Exactly, and that's another problem that I see a lot actually, is that that's another thing that other people will do if they're trying to avoid probate. Oftentimes they'll just give their property to their child. I say elderly, I just mean older people, so that's the thing, nobody knows how long you're gonna live. So if you're 75, you think, okay, I'm getting really old, or whatever, I'm gonna just start. You could live to your 90 or 95 years old. You know, it's not that uncommon anymore. And so maybe you don't want the property, but if you go ahead and give it over to your kids now, they get your basis as of now. So whereas if they held on to it, give it to them at death, then they get the step up in basis. They get the step up, so whatever the basis, so that's the thing. If the basis has gone up, because especially right now in this crazy market, prices are shooting up so high. So if you have a basis for 10 years ago, the property, and you try to sell it now, odds are you're gonna have a really big capital gains bill, tax bill to pay. But if you have basis as of like this year and then you sell it 6 months later, you're gonna have a very small, depending on, it's California, maybe not, but here, you're not gonna have a huge capital gains tax. If you inherit something, you're gonna inherit it as of the market value, as of the date of death, and then you sell it for a big capital gain. So that's another reason not to give, just straight up give property away, sort of real estate, like property with low basis, during your life. Other things, yes, if you wanna make gifts of cash, whatever it may be, that's totally fine as far as I'm concerned, but not things that have a low basis.
It says you can also do this within LLC.
Yeah,
What would be the difference between the two?
so, so within LLC, it's not as much of a will substitute as it is for the whole and sell property. But I was saying this for purposes of the out of state property, that you can do that with an LLC. So if you had set up an LLC and you transfer property to it here in Florida, you could also put property in it from another state and avoid probate in that other state because the LLC owns it, not you. So yeah, it's called ancillary probate. You have to go through probate in another state. It's called ancillary probate.
Same with the land trust. Put it in the land trust.
I'm not a big fan of land trusts, but I don't want to get into that. So here's the common mistakes. I did put these in. So the number one common mistake is not funding trust. Okay, so that happens literally all the time. Where and I know why they don't do it. I know because it's a lot, it can be a lot of work depending on how many accounts they have. If they don't have that many accounts, it's not really that much work, but it's a little bit of work. For them to contact the banks and mail the copies out of the trust, and then, especially if they don't have a financial advisor helping them, it can be some work. But if you do have a financial advisor, it's not that much work. I'll help you. That's the most common mistake that there is. And so if you don't fund the trust, you're still going to have to, your family is still going to have to probate when you die. So I think I mentioned earlier that you'll have a will. If you come to me and I draft a trust for you, you will also have a will that will kind of work together with the trust. And the will say, in addition to some other things, that all of my assets in my name as of my date of death will go to the trustee of my trust. And that's meant to be a cleanup provision, like you have maybe some small bank account or something that you forgot about that fell outside the trust. It would then get transferred to the trust as of your date of death, and then be administered all in one place by your successor trustee. But
You said it's the most common thing, so what, I don't understand, people build a trust with no funding into it?
yeah, so I'll draft the trust and they sign the trust, but then they don't, I mean, they'll fund it as far as like, if they have real estate, then I take care of that part for them, because I'll do the entity and they'll sign it, and I'll record that warranty for them, so I'll do that part for them, but what we don't typically do for them is to contact all the banks.
I'm gonna speak to that in
Yeah.
a few minutes. I'll speak to that.
Okay, good, yeah. So that, I mean, sometimes we do it, we will, but like I said, we charge for that because it's a little bit time consuming. So people often say, oh, no, it's okay, we'll just do it, and just give us the letters and we'll send it out, but then they don't do it. So if they pass away and they still haven't done it, so they have a will that says all my assets go to the trust. Some people, I've had a few of them say to me, so then why do I have to even, like, why do I have to even take the step of funding this trust? Why do I have to even move my accounts into the trust? Because the will says that everything's gonna go to the trust. Well, that's because you have to put the will through probate in order to get to that point of funding the trust. So you have to go through this whole entire process that you were trying to avoid at your death, to get the will accepted by the court, to file all the administrative documents and fingerprint fees and everything like this, to then finally get it into the trust. I don't like the word automatically. I don't know why people think, I have people ask me that all the time, doesn't this happen automatically? No, it doesn't happen automatically, there's a process for it. So you can have a trust, but it doesn't mean that you automatically, your assets are owned by a trust. You have to take some steps to make that happen. And the same thing with the will, with, okay, all my assets are in my trust, but there's a process involved in making that happen. So you have to go through the process. And I feel like I'm talking a lot about how hard it is, but it's not really that hard, it's just a little bit.
I'm
just a
gonna
little
speak
bit
to it in mind, so we can, I'm gonna.
Okay. So here's another mistake that we already talked about. Another mistake is using joint property as a shortcut, because it can defeat the objectives of your will. That I actually did not mention that, but I can't tell you the number of times I've had people come in and they want to do a will, they've got 3 kids, and they're like, okay, I'm gonna give equal shares to each child, a third, a third, a third. But then they turn around and they set up all these joint accounts with just one child. Well, what's the point of that? That child is going to be the one that inherits everything. Maybe you've got one account that's not jointly owned, it's all been over here to the side. But this is really gonna defeat their objectives if they wanted all 3 of their kids to share equally in their assets. We did talk about how putting an account in joint name with the son or daughter can expose the money in that account to the creditors of that child. That's true. And it can definitely cause family discord after death. So again, usually, now I've seen it happen both sides. So I've seen it happen where there legitimately is so there's usually one child, like I said, who is the caregiver of the parents. Oftentimes they're working really hard and they're doing the very best that they can for the parents. And the parents want to reward them and to trust them implicitly, so they'll name them as joint owner or whatever it may be, Inevitably, the siblings are going to think that that child is up to something. Like 7 to 8 times out of 10, they're going to think that, especially if the parents put this child on all as a joint owner on all the accounts. Now, sometimes the child really is up to something, and I've seen that happen a million times too, where the child is taking money that they shouldn't be taking from the parents during lifetime. But a lot of times they're not doing that, and it's just causing unnecessary. They didn't even necessarily want that this setup, as the parent insisted on it, and they didn't really know or anticipate all the problems that were going to happen later on when their parent dies. As far as siblings are all fighting that on each other, it's really damaging to family relationships. It really is. Okay, another common mistake, forgetting about beneficiary designations. So you have to make sure to update those. We talked about those. I think I've talked about that enough. Directing assets to the trust and not on that. Okay, so that's the end of my presentation.
Thank you. We appreciated that information, and we just thought it was something very important here, and here's why. I mean, literally, and I'm going to be very quick, so I don't want to go for access and questions. I'll just take it here. It's you've got a choice. You can do nothing, or you can do something. I mean, if you do nothing, I mean, I have heard people say in our office, mentality doesn't matter. Well, it matters a big deal because you need to write a whole mess for the people behind. If you love them, you don't want to do that to them. But a lot of what we do with you is we mention at the end, you come to us and we're dealing with your finances, we've transferred a lot of accounts, we've opened new accounts. But one of the things we say to you right on the end is, what about your estate design? We've been asking you all along, do you have a will? Do you have a trust? Do you have power of attorney? And you'll say yes or no. And then we say, well, how long ago did you have them last updated or reviewed, or did you have them issued? We talk like that. We're actually preparing for the back end. Where's everything going to sit? So we do that in particular because we want to make sure your wishes are carried out. We don't want to leave that mess. As Miri said, you can leave absolute chaos, or you can create a smooth transition. When we talk about your life wealth, we talk a lot also about wealth transfers. One of the biggest areas where wealth transfers occur is when you don't do something like this, when you don't set everything up clean and then coordinate your documents. The wealth transfers used to occur in taxation when we have the estate tax, but it just can happen just by not being efficient and smooth. If you can, and as Mary said, if you go through probate in the state of Florida, it's very time consuming, very costly, and very stressful on your family. So these are some of the reasons why we really do need to pay attention to our estate planning. I've noticed that a lot of clients just brush this piece off, and I think we may not have communicated to you why it was so important. So we really wanted to bring this to you, and I truly thank Mary for coming in. It really is very important that it all gets finished up. And when we talk about your estate, you've got different assets in your estate. You've got tangible assets, things like land, houses, and real estate. These are, as Mary said, they have deeds, and it's having that deed transferred correctly. Typically, we don't get involved in this piece. It's typically somebody like Mary, an attorney, and you have to think about your vehicles, your boats. These all have deeds usually that will transfer the property, but nonetheless, you still have jewelry and heirlooms. And a lot of that's probably more in the will, just mentioning your intentions and your wishes so that it's clear. So that your kids or your families or your loved one left behind is just on fighting over them. And I tell you, in recent Helgott, Helgott tells a story in his seminars about his family being split up for years over a dining room table that belonged to his grandma. One sibling wanted it, and the other one got it, and it caused a family feud forever. That should never have happened. So we don't want to forget heirlooms, jewelry, watches, furniture, precious items, things like that have gone through the family. But you also have intangible assets, and that's where we come in. This is what I want to speak to. Mary talked about, well, how do you fund these things? So things like your intangible assets are your cash accounts, banks accounts, saving accounts, money market, CDs, the brokerage accounts. That's mostly what we're working with. And your retirement accounts, as Mary rightly said, predominantly the majority of your wealth is in your 401ks or now your IRAs and those types of accounts. And annuities as well. These are the accounts that we have to make sure. This is part of what that estate design conversation is about. What do you want to have happen? We've asked you to bring your legal documents for a reason. When we know what you want to have happen, we're going to do two things with you. We're going to make sure, first of all, when we open an account, we put beneficiaries on there. Now, I have a rule. Michelle, she is there. Michelle, what is my number one rule I told you? Do you recall?
You always have to have beneficiaries.
Don't open an account without at least one beneficiary, just keep it get started, because if something were to happen, usually the spouse, we try to get the kids if we can, we may not have trust or that at that point, we'll come swing right back around and change them again, but in the account opening process right here, we do not open an account without somebody listed as a beneficiary, because Mary said it over and over again, you just don't know when something could happen, and when it happens, it can go wrong. So we try to capture at least the primary beneficiary right away, if not contingents, just to even capture that bit. But we might go right back around and change them by the time we're done on the back end, depending what's needed. So we will do with you, so we told you, you've got to name your beneficiaries. There's primaries, there's contingents. Primaries typically each other, spouse, contingents, your kids. Typically, and that's in the most basic form. Until you do proper estate planning, as I said, when we have a conversation around your wishes, this is where the trust piece comes in. Depending what needs to happen in your estate, what documents you need to have, is going to determine which beneficiary setup we ultimately end up with. But one of the primary ways to fund your trust is through the beneficiaries. If it's not retitling the account to the trust, in some instances, you retitle your accounts to the trust. I see that typically more so with couples who marry later in life. Sometimes they want to keep their assets, non-marital assets, and stay with forever. You can do that by keeping separate names. You either can keep them in separate names, which you can also do individual trust. So sometimes I see that just if you assets from becoming marital assets. Is that how you see it sometimes as well on the non-qualified? On the IRAs, typically, as Mary said, we use beneficiaries that are, once that trust is established and we have an existing trust, as long as it's good, we'll retitle the beneficiaries at that point to the trust. But going to some of the basics that you really should have, we say to you, do you have a will? Do you have a power of attorney? The very basics you should have is a will and a power of attorney for finance and health, because that's where the state's going to appoint guardianship if you don't already have that appointed. And usually there should be another one in there, directed to physicians. I just don't, or a DNR as well. That's not relevant for my conversation, but typically the basics would include that too. And then comes the point of reviewing of, do we actually need a trust? Is there a need within your setup to have a trust? And then as we do further in the tax planning, some of the other entities we start getting into are things like donor advised funds, charitable remainder trust. Again, this is all part of your wealth transfer, making sure that we're being tax efficient in what we do. Then the process with us, when we've been asking all of that, do you have a trust? Have you seen your trust? And you get that to it, you might think, well, what do you want with that? Well, because now that we've opened all your accounts, we're going to read your legal documents. We're not attorneys, and we're going to attempt to interpret them, but at least we need some idea of what you have in place. And we're going to do a beneficiary audit. Any of you had a beneficiary audit with us? Well, a beneficiary audit at some point is, yes, you have that. So we come back around saying, now that everything's in place, we want to have a conversation. We have the conversation on your estate design. What are your intentions? What are your wishes? Now we're going to do a review of all your beneficiaries, not just the accounts we have for you, but everything else that you have out there. Typically, we've got most of them, but we're going to point you back to your bank account and your checking accounts. Just go to beneficiary audit. And from time to time, we do another review. But we want to make sure, what we're trying to do is make sure that your legal documents and your accounts actually coordinate and talk to one another. So that's why that last piece is so important on the back end. If you've got existing documents, are they suitable? Are they up to date? And if they are we, once we've changed all your accounts, now facilitating the funding of the trust and your estate through the beneficiary designations or retirement, whatever is appropriate for you. So you're kind of getting the concept now of why we actually go to the trouble of doing that. Very important, because you're going to leave absolute chaos behind. It's just take a few extra steps with us to come in for a few more meetings. I know you're exhausted on the end of our process, but it is worth it to have it all lined up. And then on top of that, life happens. So from time to time, we need to revisit your documents. We do it with you during review times and things like that. Are they still applicable today? Were my wishes that I set in place a few years ago still applicable today? People get divorced. People pass away. There's birth of new children. Does everything still line up with your circumstances? So I really thank you for listening. I know we talked for a long time. I'm going to bring Susan up. She's going to say a few things, and then Mary, if you can hang around. If you want to hang around, we're going to turn the recording off, and we'll be open for some answering questions. Now, with respect, let's respect Mary. We don't. This is not a free attorney session. Just get your question. This is not. We're not going to put her in attorney role. Get all your advice for free tonight. It's not about that. And pay her fee to be here. So let's just respect that. Okay. All right. Thank you, Susan.
Sure. So thank you all so much for being here. It's nice to see some new faces and some that have been with us for a few more meetings. So thank you again for your time. Just a couple of things I wanted to cover off. So when we were having our first couple of meetings, we talked about possibly doing a trip. Didn't have enough interest early on, but I had a meeting with our travel concierge this week. They brought it up again, and I said, let me just take a poll before you all do any planning or anything like that. We just want to see if this is of interest in all. So we have a couple of ways that we can schedule this. It would be the primary purpose of the trip is just to be able to engage and meet the ladies and all that. So it would be a girls' trip. But there's also a second option, whereas if we were here, let's say we did a 3 or 4 day trip with the ladies, you could have your spouse or significant other kind of things they've passed out for us earlier, we're probably in the $2,000, maybe $2,500 range. You all had listed your top